You're listening to God, Law, and Liberty with David Fowler and Gary Humble. We're putting culture on a collision course with the truth.
Welcome to another episode of God, Law, and Liberty. I'm Gary.
And I'm David.
Good to see you again, David. You know, I don't get to see you in the office anymore, so this is like Skype's my only chance to hang out with David Fowler.
This is it. Well, I was in the office yesterday. You could have come by.
Yeah, just I wasn't. Yeah, it's true.
yeah. But anyway,
well,
this has been an interesting time, isn't it? We're talking about that some today too.
Yeah, there's always something going on. I mean, every day we could do about 10 podcasts. It seems there's just huge issues hitting us around every corner.
Sure. People don't probably appreciate that we may spend an hour talking about which of the many things we should talk about this week and which one wait till next week.
What are we going to talk about? Yeah, absolutely.
Yeah.
Well, one of the things that happened this week, I believe, that I thought was pretty pertinent to what we typically talk about here on God, Law, and Liberty was this issue in Dallas, Texas, where a district judge, jailed a business owner for opening up her business. And so definitely want to talk about some things surrounding that issue. And then also want to get into a little bit these executive orders that have been issued around the country and including here in Tennessee, which frankly, I was shocked that we actually issued a stay-at-home order here in Tennessee, but everyone did. So, but kind of want to talk about those executive orders, the force of law they actually do have, what happens when these things are unconstitutional and how does that work? Mm-hmm. I don't think we'll have all the answers, but it'll be good discussion nonetheless. So let's talk about this thing in Dallas, David. I'll play, I'll kind of set this up and we'll play this clip here real quick.
Yeah, explain to what people happen that they don't, if they hadn't seen it.
Yeah, essentially, just like our state here in Tennessee, Texas had a stay-at-home order, and they also ordered certain businesses to shut down and put in certain requirements and put a bunch of guidelines in place and defined essential versus non-essential businesses. So everything that's happened all around the country. And so this woman who owns in Dallas, in North Dallas, I believe, she owns a salon, and admittedly, she's hurting, right? She's hurting. Her employees are hurting, struggling to put food on the table for their kids. Because one of the points she made is as a cosmetologist or whatever you call it, if you're working in a salon, you're a contract employee. Right. So, which makes things a little bit different as far as getting certain benefits. Right. Unemployment even and things like that, because you're not technically on a payroll, right? You're being paid by contracts, so you're sort of self-employed. So that puts people that work that cut hair for a living in sort of a unique situation. So that was kind of part of her reasoning, like this is our only way to make money. If we're not cutting hair, we're not making money. There are no options here. So anyway, she opened up her salon. I don't know how she got found out. Maybe it was one of those. We have a lot of these little snitching laws going on around that, which are unique in of themselves. But in any case, she got brought before the court, and the judge sentenced her to 7 days in jail, a $7,000 fine, and $500 a day for every day that her salon continued to stay open. Thankfully, Governor Abbott got involved. The Attorney General, the Lieutenant Governor,
he offered to pay the fine and go to jail for it.
Dan Patrick, and then the Attorney General Ken Paxton got involved, and all of them, all three of them, sided with the business owner in this instance.
And actually, wasn't it a Dallas order that she really violated? Not even the state one. I think Dallas had its own.
I believe it was a local order. Yeah.
Yeah. So that's a whole nother layer of issues right there.
So that's sort of what happened. And here's a clip from her attorney was interviewed on the Tucker Carlson show on Fox News. And here's that clip.
She has to bend the knee. I mean, that's what he wants. And in the order, even in the order for contempt that he says, if you will but express contrition and apologize, then we could look at doing this and we could fix this. The idea that Dan Patrick or anybody could take the place is not going to be sufficient. They want her to bend the knee. Nothing else will suffice.
Is that allowed? I mean, I don't know where, I'm not that familiar with the Texas legal code, but is there a law in Texas that says you have to grovel before morons who are wearing robes? Is that part of the law there, or is that just something he made up from the bench?
I appear before a lot of judges, Tucker, so I can't say that too much, but I can tell you that I've never seen that. I've never seen it. And I've had judges that are mad at me, but I've never had a judge say, you must admit how selfish you're being in order to for me to grant you mercy. He didn't have to do that. He could have said, look, I know you're just trying to earn a living, but I've got to enforce the law. So I'm going to hit you with $500 a day and let you go. He could have done that, but that wasn't what he wanted. He wants the contrition. He wants that apology. So
the most interesting thing to me about this clip, and the attorney makes a great statement at the end, is that the judge had the ability to make a whole host of judgments here, I suppose I should say.
Sure. Sanctions.
Yeah.
Choice of sanctions. Yeah.
He could have issued a small fine and just walked away from it, upheld the law as he saw, right, fined her and let her go on about her business. But right, that wasn't enough. He not only, I think, gave a really extreme sentence, but I'll let you speak to this. He needed her to apologize. Yeah, and yeah, that's an interesting thing, I think, for a judge to require. Typically it's, well, did you break the law or not?
That's right.
But that wasn't good enough. And so I'll have you weigh in on that, David.
Well, let me quote. There's another news article that actually quotes some of what he said to her. He says, "You owe an apology," now I'm quoting, "to the elected officials who you disrespected by flagrantly ignoring and in one case defiling their orders that obviously apply to you. You need to understand that the proper way in which an ordered society to engage concerns that you might have had is to hire a lawyer and advocate for a change, an exception, or an amendment to the laws you find offensive." And she said, "Well, I'm not going to apologize." Now, if you ask me, that is the epitome of government-compelled speech. As her lawyer said, he wants her to bend the knee to him. That's what he wants. And that's constitutionally, to me, offensive. I'm entitled to, I shouldn't say entitled, but yeah, I'm entitled to break the law. I'm responsible for the consequences of it, if I break it. But I don't have to give an apology for breaking the law.
Yeah, if I have a principled purpose for breaking the law, I mean, I can own that. That's what I did.
I can own it. That's right. And I hate to say it, but this judge here should be brought up in front of the judicial panel. And if the Texas Judiciary or Judicial Conduct Board or whatever does not publicly sanction this judge, if I were a member of their General Assembly, then I would say, we're going to remove you. I don't know what their removal provisions are, but in Tennessee, 2/3 of the General Assembly, the House and the Senate, can remove a judge without having to, quote, impeach them. People don't know that. But you can remove the Attorney General, you can remove judges for cause spread upon the record. And without going through the normal rules of what all an impeachment would be. Again, you'd have to have 2/3. But this is really outlandish. It is arrogance. Now, one thing we need to report, since we even started looking at this issue this morning, her attorney filed a writ of habeas corpus. People may have heard that term or read that term, but what it is it's an old English common law. We've talked a lot about the common law writ that commands you to bring the body to the court. And it deals with the potential for an unlawful confinement. So the higher court would issue a writ to bring that body to me because I want to make sure they're confined properly. So that emergency writ was filed with the Texas Supreme Court, I think maybe yesterday afternoon. And today, the Texas Supreme Court granted the writ and ordered that she be released from parole on her own recognizance, without any bond or anything, until these proceedings can be looked at. And that's what a writ of habeas corpus is. It's one of the things in our Constitution that the writ of habeas corpus is not supposed to be suspended, because the whole idea is we can have little tyrants down below us, and somebody higher up needs to be able to yank their chain and pull that body out of the jail or confinement and re-examine the situation. And that's exactly what the Texas Supreme Court did. And now the next thing is somebody needs to file disciplinary charges against this judge.
Yeah, that's the last thing that needs to happen. I mean, the one thing we can say about this situation is yay, Texas leadership for taking the right stance, doing the right thing, making the corrections.
That's right.
I think the last thing they need to do is to restore confidence in the court to the people of Dallas. You know, is this judge needs to be disciplined and needs to know that this is inappropriate. Just you can't treat citizens that way.
Yeah, can't do it. So so that you know, now there's another issue here we didn't talk about, but we can talk about it now if we want to. Is we're dealing with situations that, to be honest, at the state level, I'm saying now, that we've probably not really thought through too well. Mm-hmm. The legislature passed a statute. I think I looked back. Did I say it was in 2000 or something?
Here in Tennessee, you're talking about. Yeah, that was in 2000. In 2000.
Yeah. So you know, I'll just admit right now, everybody be mad at me, I was still in the General Assembly in 2000. I don't know if I voted for it or not. I mean, that's 19 years ago.
Can you clear up what statute are you talking about?
I'm talking about the emergency powers provisions of the Tennessee Code that allow the governor to, in essence, suspend the laws for up to a 60-day period. And every time, at the end of every 60 days, it would have to be renewed, you know, and he could declare a state of emergency. And, you know, probably nobody thought about this in terms of a statewide emergency so much as what happens a lot of times. You know, you have a tornado go through Wilson County or something over there and destroy everything, and he declares a state of emergency, oftentimes just in order to get federal funds for, you know, emergency, not. But theoretically, it could happen if there are big race riots going on. You know, he could suspend some laws to bring, you know, quell civil unrest.
Yeah, according to the statute, just declaring an emergency in essence expands his powers.
Yeah, that's right. And like I say, it's only temporary, although it can keep getting extended. And I don't know if there's a limit to it. You know, kind of like term limits. Yeah, you can extend it twice. After that, you know, you need to get legislative approval. And I have noticed that at least some of the states that we've worked with in our family policy network, some of them are indicating that their legislature is now taking a look at these emergency powers that all governors have.
As well, they should.
To examine what is the check and balance on these things. You know, because they could put, essentially they put all the power and the authority of the legislative body in the hands of the governor.
Right.
And, you know, and then if you don't have a decent governor, people drunk with power, I mean, this is just right up their alley, right? So,
and so just so people know, I'd like to give a little bit of a timeline or a history, so to speak, of what happened here in Tennessee, which I don't, which you know, I want to say up front, I'm not like I said when we were discussing it, this isn't a dig on the governor or anybody. I think, you know, we've seen this go down in every state, and I think simply where we are today, it should cause us all to question these statutes. How much power should we really hand over to an executive in a time like this? So what's happened in Tennessee is when the governor began to put out these executive orders, we had the members of the General Assembly requested an opinion letter from our Attorney General on whether or not these executive orders were appropriate, essentially, and how far can they really go. And the Attorney General responded, I think, on April 27th with an opinion letter, and essentially quoted the statute that you brought up that was passed in 2000, and essentially said, yes, the governor certainly does have all of the powers and authority that he is executing, and he's doing them appropriately, and he has the power to make these executive orders, and he has the power to not only use the power himself, but to delegate his power to other agencies. And he has complete discrimination as to when he takes that power back and how long he gives that power and all those sorts of things. So that went on. And then on the thing that I found interesting that I'd like to talk about a little bit was, and maybe it was, who knows who drafted these orders and who advised me to do this, but I just thought the wording was so interesting. On March 30th, the governor issued his executive order number 22. He issued the first executive order we had for basically a suggested stay-at-home order. And in that executive order, there were 2 whereas clauses that I thought were pretty critical, which I think go to why he suggested the stay-at-home order and didn't mandate it, was because it says, whereas, because protecting personal liberty is deeply important, this order is not a shelter-in-place mandate and instead strongly urges Tennesseans to stay at home, ... Which I thought was great. I applaud Governor Lee for that executive order. That's fantastic. Yes, provide guidelines, let people know what's going on, provide resources to the state, to businesses, and so on and so forth. And let's ask people to stay home, but let's acknowledge that, hey, we have liberty here, and we're not a police state, essentially.
So sort of, here's what you need to know, now act like grown-ups.
Exactly. Yeah. Practice some personal responsibility.
Right.
In fact, the very next whereas clause says, just so you know, guys, personal liberty comes with great personal responsibility. So they even kind of put that in there. And I was like, yeah, that's appropriate to say. But my problem is 3 days later, on April 2nd, he issues executive order number 23. And the whole point of this executive order was to simply correct one word. The word changed from urged to stay home to required to stay home. And so after talking about how great and important personal liberty is, 3 days later, personal liberty's overrated. You need to go ahead and stay home. And so now Tennessee, basically put itself in the situation that all these other states are in. Well, now what do we do? Because we've mandated people to stay home. Are we going to enforce it? How do we enforce it? Are we going to penalize people, if they don't stay? Because now you've got to answer all those questions because you've created a state mandate. I'll let you weigh in on that a bit.
Well, the mandate's only as good as the enforcement mechanism behind it, and that's some of the challenge in all of this. And next week, I hope we can have we can try again with Dr. George Grant and have him on to talk about this concept of the lesser magistrate. And
very applicable.
And because there was actually another little thing that came out from a district attorney general. See, the laws are actually enforced at the local level. We don't have a attorney general district attorney per se. General Slattery's not got people trying criminal cases down in the county courthouse. He handles appeals mostly, and it's not to say that he can't get involved in a trial case. He does, but the district attorney generals have to decide: am I going to prosecute this or not? Now they have their own constitutional obligations. They have their own constitutional authorities. So, for instance, this Attorney General Steve Crump, and I don't know if you have it in front of you. I don't know what judicial district he's in, but he's somewhere up there.
Yeah, he's the 10th judicial district. Yeah,
10th judicial district. He said, "Look, I'm not going to prosecute anybody because, in my opinion," he said, "now I have authority to do this, and I can be responsible, but I'm going to stand in the gap for my citizens and say all of this has gotten terribly arbitrary. If you happen to be 10 feet on the inside of my county line and you're a barber, then I could prosecute you. But if you're 10 feet on the other side of that line in the competing barbershop, well, then that's a different situation. And the one thing the rule of law is it should not be arbitrary. I mean, that's the whole point of the rule of law. And so when you have laws that will I don't get it. Why is it that I can go to Kmart and I can go to the Sonic drive-in, but I can't have a drive-in parking lot church service? Now our governor did not mess with churches, and I'm thankful for that.
He actually went out of his way to protect churches during this, which I have great respect for.
Sure, absolutely. But you got legitimate questions here. Mm-hmm. So I can stand in line at Walmart behind you buying stuff, but I can't go to a salon that's got every other chair open. I mean, what's sort of with that? So he just said, look, I'm not going to enforce these laws. They're arbitrary. I took an oath, and the voters of my district can hold me accountable if I violated this oath, but I'm not going to enforce this law. And, the authorities above me can come after me if they want to. That's the doctrine of interposition, the doctrine of the lesser magistrate, who steps in and exercises the authority he has on behalf of those that are under him with respect to those who are over him. And that's critical. And see, that's what this judge over in Dallas, he's like, we've created this caste system, lady. You don't understand it. We are your superiors, and you must confess that you have offended us and disrespected us, and so on and so forth. And
he's the worst kind of lesser magistrate.
Yeah, that's right. And thankfully, the upper magistrate stepped on him,
right,
and said, "Let her go."
The opposite actually happened.
Yeah, they actually happened, right?
Yeah.
But we don't understand too the responsibilities of our sheriffs. We have constitutional sheriffs now. People don't appreciate that
here in Tennessee.
But yes, absolutely, the sheriff's office is created by the Constitution. Now we elect them locally, but they are constitutional officers. The same as the governor, the secretary of state,
county clerks,
comptroller, county clerks. That's exactly right. And so the sheriff has a great deal of authority to be that lesser magistrate, to interpose himself in certain instances, to say, no, I'm not going to do these things. Now, unfortunately today, because we've lost that whole doctrine, and because the church doesn't even know that doctrine exists, the church doesn't know that doctrine arose out of the Reformation and the fights between the governments that were Catholic and the ones that were Protestant, and everybody's throwing everybody in jail and all that sort of stuff. We don't even realize that that's exactly what we intended. It's part of that system of check and balances. We think, well, Congress checks the Supreme Court, and Congress checks the president, and the president checks Congress, and the states help check the federal government. Well, that's all true. But see, we have all these other lesser magistrates who are established, who are not under, who in essence are their own authority in some ways. Now, the General Assembly passes laws to tell clerks what to do, okay? And sheriffs, here's how far your authority can go. But they have their own constitutional obligations. And so sometimes we get mad at officials and think they're being lawless. And sometimes they are. But they're also, at times, like this Mr. Crump, saying, I can't in good conscience, under the concepts of rule of law, go out here and put this lady in jail for her salon, and not put the waitress at the Sonic drive-in in jail too. Mm-hmm. I'm just not going to do it. And so this I hope is a part of this COVID thing. This is why I think it's good we're talking about this. That we need, particularly as Christians, to think about some deeper issues, not just what's the letter of the law, but why are we structured the way we are? Why are our sheriffs put in the Constitution as separate officers, not under the executive branch or under the Attorney General's office?
I think that's a great structure.
Yeah, we're creating checks and balances against everybody because, as we talked several weeks ago, as you said, what was it, Federalist 10, paper 10 or 57? Men are sinful. Men can be terrible.
That's Federalist 6. Or
was
they
it 6?
are, let's see, ambitious, vindictive, and rapacious.
Yes, that's right. Yeah. Not a very nice description of who we are. It's sort of like the Bible with different words. But now another issue that's come up. This is fascinating. You and I were talking about it, and I don't really have an answer to this. But the governor issued these orders, and he said, "Here they are. Now, counties started issuing orders too, some counties and some cities. Well, the Attorney General said, well, wait a minute, you don't have any authority to go beyond or do less than what the governor says, unless the legislation gives you that authority. So when you had some little guy over here, in some city, and I don't know if we had one that went crazy, but that went out here and said, okay, well, here's what you're going to do over here in Weakley County, or here's what you're going to do over here in Lawrenceburg.
Yeah.
We're going to really do this. The law doesn't give them that authority. In some ways, what this COVID has done is it has exposed the people who are little tyrants in waiting.
All over the country.
Yeah, that's right. Their lust for power. Here's something, I'm going to grab onto it until somebody stops me.
Yeah.
Now the challenge that you rightly noted is that when the governor let his executive orders expire at the end of the month, he did say he was going to allow the health departments in, I think,
there are 6 counties that have their own health departments outside of the state health department. Yeah.
Okay. And so he's going to let them make their own decisions. Now, the question is, well, why did he not let them make their own decisions to begin with? Right. Once he decided he wasn't going to let them make their own decisions, why is he now letting them make their own decisions?
He should have stuck with that plan.
Well, except that, we have to note that the statute dealing with the health departments allows the health departments
to do that. Well, it also allows him to delegate his power to the health departments as well.
Well, that's right. Yeah. But the statutes also delegate more authority to those county health departments.
Itself, yeah.
That's right, because the rest of them are operating under the state health department. So I'm sure nobody really thought too much when they passed these executive things and they passed the thing about the health departments. Well, what happens when we have something where the governor issues an order across the whole state and then all of a sudden it's undone? What do we do? And again, I'm not saying the governor did anything wrong. I'm just saying it shows that the laws weren't very well coordinated. I'm not faulting anybody. Like I say, I voted for at least one of them, the Governor's Emergency Powers Act. But we didn't think how they all coordinated and how we stay consistent, how we don't look arbitrary on the one end and then look arbitrary on the back end. And I hope, our legislature, not as a rebuke to anybody as much as just, hey, sometimes you see how things work and you go, maybe we ought to revisit that. Maybe we ought to think through how does all this stuff play together. And several states are doing that.
The scary thing too, as I think about it, in general, there are some things that, Governor Bill Lee did that I don't personally like. At the same time, I can't say that, especially in comparison to what's happening around the country. I mean, I think it's been pretty tame.
Yeah.
And I think he's done a good job in general of moving through an unprecedented time that certainly hardly anyone has been through in our lifetime. But what scares me with the kind of power that he wields as governor with these executive orders is, what if we had a different guy in the office?
Yeah, that's right.
That's scary. What if we had some power-hungry, crazed individual?
What if the governor of Michigan got elected
like the governor
here?
of Michigan? Exactly. I mean, I look at the way that statute reads under these emergency powers, and I'd like to think that it would be more appropriate that if you're going to literally shut down the state and close business, literally shut the state economy down, that somehow that should be part of a legislative activity and not just some rogue executive deciding, I'm going to shut everything down. Even if the legislature has to connect by Zoom or whatever it takes, like, there should be more voices included in that decision than just an executive. It's probably the biggest thing I see, but I'm sure there's other things too. But anyway, scary stuff.
That is some of the states have. I haven't read the details of it, but some of the states are looking at the governor needing to have some kind of sign off from various other people, so they just can't declare it an emergency himself.
Even if it's maybe just from the speakers. of the Senate.
And now the challenge that you get into there is delegations of authority, where I ran into a situation years ago where Governor Sundquist applied for federal money, and the law allowed the chairman of the House and Senate Finance Committees to approve or sign off on the application. Okay? Well, only the General Assembly can appropriate and spend money and so on and so forth. And that's fine when the General Assembly says, okay, we're going to get into the Medicaid program. Okay? And so we've in essence authorized the governor to fill out all the paperwork to draw down the money for the program. Okay? And we just want to know that you've applied for the AFDC money or whatever it is. Well, in this particular case, what happened is the governor decided to get into a program that the General Assembly had never approved. So it's kind of like, oh, here's a new government program. I will go get the money, and I'll send a notice to the chairman of those committees. But see, they had no authority to approve a new program. You see what I'm saying?
Yep.
In other words, they could sign. It's like me saying to you, Gary, you can go down to the bank and get new checks. Well, I've authorized you. You can go down there and do that. If you go down and put all our money in the stock market or something, I might say, hey, wait a minute, who authorized you to do that? So
that
there was
a signature on the check, though. That's the tricky part.
Yeah, it really is, and having our board chairman and people reviewing all of our check statements and all that. But
we have our own checks and balances. See,
that's right. We have our own checks and balances, and ultimately we have a real check and balance. But the point is, there was another situation where we created a law, and in some ways, it hadn't dawned on me till I said this. It was a little bit like the refugee thing. If in other words, what happened then, back in 1998, was that Congress authorized governors to go get money for a new program and bypass the legislature. Why? Because under the Clinton administration, they didn't think a lot of states would approve the program, but the governors might. Well, see, that's exactly sort of what happened with the refugee thing. State says, we don't want the refugee program. And then along comes, well, the federal government will let the governor do this, and the governor does it. And it's kind of like, well, wait a minute. We didn't authorize you to do that. Yeah, but the president did. Well, the president can't authorize you to do something
our
Tennessee
state
law.
Constitution doesn't, though. Yeah,
that's right. So all these issues really need to be looked at. They need to be thought through. And we'll say it, I'm sure, a million more times if we do a million more podcasts. It goes back to what de Tocqueville said. We have these wise procedures. We often don't know why they're there, and then we make a clumsy use of them. And then when we see that they don't work, we don't really know how to fix them because we don't know the underlying principle that gave birth to it.
Right.
So anyway, we both found the situation with that judge entirely out of line, and the fact that he's doing it under a city ordinance, and you got one law applying in Dallas and another law applying in Austin and another law applying in wherever, and this has given us a good cause to re-examine a lot of the things that we've set up and reevaluate.
Well, I don't have her name in front of me, but to the lady who's this business owner of this salon in North Dallas, bravo.
Hats off to you.
We applaud your stand for liberty, and also
makes us proud that Davy Crockett went down there, doesn't it?
That's right. That's right, from Tennessee.
That's right.
And
that's right.
And at the very least, people at Dallas know that there's at least, I'm sure there's several folks here in Tennessee that stand with you in your plight for liberty, and we really hope that Dallas judge either gets sanctioned, or I'm just speak for me personally. I think he should be just removed from the judiciary completely. That was an incredible lapse of judgment for someone whose responsibility it is to uphold the Constitution and like you said, be a good lesser magistrate. He definitely failed in this particular instance. So, well, David, thanks for
Hey,
a bit of commentary
podcast.
on
next
this.
week we'll have I think if we can get George Grant on, I think this will be good too.
If we can connect on Skype.
Magistrates. Yeah.
We'll work it out.
Good.
All right.
Okay, no.
See you next time.
If you enjoyed this episode, don't forget to subscribe. And if you want to help spread the word, please give us a 5-star review and tell your friends to subscribe too. We're available on Apple Podcasts, Spotify, and wherever you listen to podcasts. God, Law, and Liberty is a podcast of the Family Action Council of Tennessee. We are a 100% supporter-funded nonprofit advocating for family, life, marriage, and religious liberty. For more information, please visit us at www.facttennessee.org. That's FACTennessee.org. And please follow us on Facebook, Twitter, and Instagram @FactTennessee.